Okay, I don't have time for a cell phone. This is ridiculous. CHP is arresting engineer Gregoire for where he spotted the fire engine.
Or it could be that it's just such an outrageous thing to do that nobody's ever done it.
What you just saw happened on the night of February 4th, 2014, on an Interstate 805 freeway in Chula Vista, and no charges were ever filed. No conviction, no warning, just handcuffs, applied to a man who was actively treating a patient. But the officer who made that arrest had a defense that had worked before, in courts across the country, hundreds of times. What that defense ran into inside a Ninth Circuit courtroom 3 years later was a federal judge who had 4 words for it.
Deputy Attorney General Robert Murgoyski from the California Attorney General's office, here on behalf of defendants, appellants, California Highway Patrol, and Officer Sergio Flores. I'd like to reserve, if I may, 3 minutes of my time for rebuttal. This is a qualified immunity case, and the court should find that the doctrine of qualified immunity applies to both of the federal claims in this action. I'm going to start today by talking about the arrest claim, and then I'll move on to the excessive force claim, and then if there's any time remaining, I'll address the issue of jurisdiction over the state law claims. So starting first with the question of qualified immunity for the arrest. There are 3 independent reasons why this court can reverse the lower court, but the most straightforward is the second prong of the qualified immunity test. Here we have 2 competing interests. On the part of the fire department and plaintiff Gregoire, there was an interest in management of the scene in terms of taking care of the patients who were present on the scene. That's their perspective. From CHP's perspective, there's a very important competing interest in protecting passing motorists who are going by a freeway that's partially blocked by fire engines and by a squad car and by an ambulance from subsequent accidents, being injured or being killed on a busy freeway at night. So we have these two competing interests, and against that we have a set of state statutes that don't explain what consultation means, and they don't explain which of these competing interests predominates.
Well, doesn't that case, the County of San Bernardino versus City of San Bernardino, kind of outline who's in charge of what in terms of emergency scene operations?
Yes, and the statutes give a general outline.
Clear that the police are in charge of the scene management, but medical personnel are in charge of patient care decisions, right?
Yes, but the specific provision at issue there comes down to Health and Safety Code 1798.6, which says that priority goes to persons exposed to the most serious risk. It doesn't say how you figure that out. Is the most serious risk the patients who are on the ground, who were recovering from the accident?
Well, this is a case of disputed facts, and I realize that the parties have different stories, but suppose we take this and look at the facts in the light most favorable to Gregoire, the non-moving party, and his witnesses. They all seem to say that he was actually attending physically to a patient